Good evening, viewers. I, Dr. Neepa Vyas, Assistant Professor from Government Law College, welcomes you to the second session of the day where we will discuss about abolition of capital punishment, a conundrum. I have kept the title as a conundrum. The only reason is that I think that the statement itself is such that we will have always two types of answers. One will be of the view that it should be abolished, and the other view we will always get, that is, no, it should be there, it should not be abolished. So, to justify the title, I would like to discuss the topic in three phases. First phase, in which we will discuss about the international documents which provides for capital punishment, that is death sentence. In second phase, we will discuss what is the scenario in other countries, other nations. And lastly, we will discuss the situation of India. What are the views of Indian Supreme Court? What is the provision in our constitution and other relevant acts? So let us start with the first phase. I would like to share the provisions of Universal Declaration of Human Rights 1948. Dear viewers, two articles are very important, but as particularly for today's topic. Article 3, which prescribes that everyone has the right to life, liberty and security of person. At the same time, Article 5 prescribes that no one shall be subjected to torture or cruel, inhuman or degrading treatment or punishment. Dear friends, these two articles safeguards the right of life of each and every human being. And at the same time, it is also provided that no inhuman punishment should be awarded to any human. Don't you think that this will go against today's topic? How can we abolish or how can we implement the capital punishment when the Universal Declaration on Human Rights, to which many states have ratification, implemented the provisions of this Human Rights Convention in their countries? But friends, this Human Rights Convention is not mandatory to be followed if it is not in accordance with the law of the land. So, each and every state or municipal law permits, then only international agreements will be implemented in their states. So, keeping in mind these two provisions, let us discuss the scenario of the world. As the United Kingdom, which also the party to the Human Rights Convention, abolished, I repeat, abolished the capital punishment in 1965. Before 1965, the capital punishment or death penalty was there in their statute, but it was never declared as inhuman or cruel. But by passing the particular Act of Murder Abolition of Death Penalty Act 1965, then after the capital punishment was abolished in United Kingdom or UK, as you all are familiar with. The second country which I opted is Australia. In this state also, by passing the Act of Death Penalty Abolition Act 1973, the death penalty was abolished. Section 4 of the said Act provides that a person is not liable for the punishment of death for any offense. I repeat, no person shall be awarded death penalty for any type of offense. It may be inhuman, cruel, heinous, anything. And to implement this section 4 or there to protect the particular provision again in the same act, section 6 repeatedly provides that the punishment of death must not be imposed as the penalty for any of the offense. So this is the repetition of the provision that section 4 is again reiterated by changing the words in section 6 to make sure that this punishment shall not be imposed as a penalty for any offense. This act came into force in 1973. So Australia also has abolished the capital punishment. We are still discussing the developed Western countries, my dear friends. The third country which I opted is Canada. The Canada has passed in 1998 the bill which is known as C-25 by the House of Commons that capital punishment is abolished. So, by this passing the bill, the capital punishment is also abolished in Canada. The fourth country is France, where Constitution of France was amended in 2007 and Article 66 Clause 1 was inserted, which provides that no one shall be sentenced to death. So there is no other option left, that it says that the capital punishment or death sentence is abolished in France since 2007. The Germany. The Constitution of West Germany in 1949 by its Article 102 provides that capital punishment shall be abolished. So, in most of the Western developed countries, they are of the opinion that the capital punishment should be abolished, and they have abolished by passing relevant acts, statutes, or by making amendments into the constitution. Why? Because they also have ratified the Universal Declaration of Human Rights, and to implement those two provisions provided under Article 3 and Article 5, they amended the acts and implemented it in their relevant countries. Now friends, you must be thinking that if all countries have abolished, is India the only country who is yet implementing the capital punishment and awarding the capital punishment? You must aware that very recently in Nirbhaya's case, 13th February 2020, the accused persons were hanged, where the capital punishment was implemented. India is not the only country which is yet inflicting the capital punishment. Then which is the other country? It is the United States of America. This particular country, United States of America or USA, providing by its 8th and 14th of Amendment in the Constitution that particularly the 8th Amendment prescribes that excessive bail shall not be granted, imposing terrific fine is not permissible, nor the state can inflict or implement any cruel or unusual punishment. This is the 8th Amendment to the Constitution of United States of America. And then after the 14th Amendment, which is available to your screen, provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. This is the 14th Amendment made to the United States of America's Constitution. You must be finding that these provisions are similar to the provisions of Constitution of India. Similar provisions are also prescribed in Indian Constitution through Article 14, 19 and 21, to which we are calling it the golden triangle of our Indian Constitution. Because our Article 21 is inspired by this particular Amendment of United States of America, which provides nothing else but liberty of equality, right to life, and the fundamental freedoms. By keeping in mind these two provisions of United States of America, the constitutionality of death sentence or capital punishment was challenged in the case of Furman versus Georgia. Okay friends, here I am pausing myself and instructing you that if you have any query, you can comment in the comment box, and at the end of this session, I will deal with all the questions raised by you. So if you have any query, you can ask me by inserting in the comment box. I will not continuously looking in the comment box because it is not convenient to go through, and it will not, or rather it will break the flow of the session. So I will answer the comments at the end. And as I am instructed, I will also deliver the session in Gujarati as well as in Hindi also, so that to cater all the wishes of the viewers. તો here friends, થોડુંક હું તમને ગુજરાતીમાં પણ કહી દઉં કે યુએસએના કોન્સ્ટિટ્યુશનમાં 8મા અને 14મા સુધારાથી જે બે જોગવાઈઓ કરવામાં આવી, એમાં 8મા સુધારાથી એવું કીધું કે કોઈ પણ વધારે પડતા દંડ નહીં લેવામાં આવે, કોઈ અમાનવીય અથવા તો ક્રૂર લાગી શકાય એવી શિક્ષાઓ કરી શકાશે નહીં. અને 14મા સુધારાથી દરેક વ્યક્તિને સમાનતાનો, જીવનનો અને જીવન જીવવાના અન્ય અધિકારો અને ફ્રીડમ્સનો પણ ગેરંટી આપવામાં આવેલી હતી. આ પ્રોવિઝન્સને ધ્યાનમાં રાખીને યુનાઇટેડ સ્ટેટ્સ ઓફ અમેરિકામાં 1972માં પહેલી વખત કેપિટલ પનિશમેન્ટને ચેલેન્જ કરવામાં આવી in the case of Furman versus Georgia. હવે in this case, the judgment is very important, and because the judgment is given by 5:4 judges, એટલે total 9 judges ની બેન્ચ હતી, અને એમાં મેજોરિટી જજમેન્ટ જે હતું એમાં પણ બે વ્યૂ જોવા મળેલા હતા. 2:3 judges નો રેશિયો એમાં હતો, where the majority judgments, where 2 judges were of the opinion that it is in contravention of the amendment of 8th and 14th, and it is inhuman, the capital punishment. This was the view of 2 judges. 3 judges of the majority side were of the opinion that this is not unconstitutional, but it should not be implemented. They were of the view that it should not be abolished. They were of the view that if alternative punishment is available, it should be implemented except capital punishment. And the minority view, that is the 4 judges, were of the opinion that it is neither in contravention with 8th or 14th amendment to the constitution. So we got the judgment that the imposition and carrying out of the death penalty constitute cruel and unusual punishment in violation of the 8th and 14th Amendment. So in 72, it was declared that a capital punishment is violative or unconstitutional. Then again, the question was put before the Supreme Court of United States in the year of 1976. Dear friends, in Gregg versus Georgia, again here Georgia is the common name. So if you are listening this session for your exam purpose, you have to remember only 3 names: Furman, Georgia and Gregg. Furman versus Georgia, where it was held unconstitutional, and Gregg versus Georgia, there it was held that it is not unconstitutional. It is not violative of 8th nor the 14th Amendment of the Constitution of United States, whereby the judgment which prescribes Justice Stewart, Justice Powell and Justice Stevens. Justice Stewart was also the judge of the majority view in Furman versus Georgia, who was of the belief that it should not be abolished but alternative punishment should be implemented. Justice Stewart, Justice Powell and Justice Stevens formed the majority view in Gregg versus Georgia and held that the punishment of death for the crime of murder does not under all circumstances violate the 8th and 14th Amendment. એટલે 8મા અને 14મા સુધારાને કેપિટલ પનિશમેન્ટ કોઈ પણ સંજોગોમાં ભંગ કરતી નથી, એટલે કે એનો ઉલ્લંઘન થતો નથી, એટલે કે એ બંધારણીય છે. આ જ વ્યુને ત્યારબાદ સુપ્રીમ કોર્ટ ઓફ અમેરિકા દ્વારા પણ વારંવાર ચુકાદો આપવામાં આવ્યો કે જેમાં 3 અગત્યના કેસીસ છે: વુડસન વર્સિસ નોર્થ કેરોલિના ઇન 76, Robert versus Louisiana in again 1976, and in the year of 1977, Supreme Court of United States held capital punishment is constitutional in the case of Gardner versus Florida. So let us conclude the international scenario that the capital punishment in United States of America is not unconstitutional per se. So in UK, Australia, Canada, France, Germany, in all these states it is abolished, but in United States it is not abolished and held constitutional. Now let us discuss what is the position in India. I would like to discuss the position of India, or whether the Supreme Court of India is of the opinion to abolish or not to abolish the capital punishment in these 6 cases. આ 6 cases through આપણે ચર્ચા કરીશું કે ભારતની સુપ્રીમ કોર્ટ દ્વારા જે કેપિટલ પનિશમેન્ટ અથવા તો જે ફાંસીની સજા આપવામાં આવે છે તે બંધારણીય ઠરાવવામાં આવેલી છે, ગેરબંધારણીય ઠરાવવામાં આવેલી છે કે બંધારણીય ગણવામાં આવે છે તો કયા કારણસર એને બંધારણીય ગણવામાં આવેલી છે. So let us discuss the first case, Jagmohan Singh versus State of Uttar Pradesh. The citation of the case you can see from this slide, AIR 1976 Supreme Court, page number 947. આ કેસના જજમેન્ટ પર પહોંચતા પહેલા I would like to discuss some fact of the case. I hope you all are with me and you are able to understand what I want to convey. If you have any query, just write a comment. We will discuss it at the end of the session. According to the fact of the Jagmohan case, why? Because sometimes the knowledge of fact gives or aid to understand the judgment. This is the reason why I am mentioning the fact of the Jagmohan Singh's case. હવે આ કેસમાં એવું થયેલું હતું કે શિવરાજ સિંઘ જે આ જગમોહન સિંહના કાકા હતા, who was the uncle of Jagmohan Singh, that was Shivraj Singh, who was murdered by one Chote Singh. છોટે સિંહ નામની એક વ્યક્તિ હતી, એને શિવરાજ સિંહનો ખૂન કરેલું હતું એવો એની ઉપર આરોપ હતો. અને આ શિવરાજ સિંહ એ જગમોહન જે આપણા કેસના જે પાર્ટી ટુ ધ કેસ છે એમના અંકલ હતા. The case was held before the High Court and High Court acquitted Chote Singh. એટલે છોટે સિંહને હાઈકોર્ટે છોડી મૂક્યા. એવું પુરવાર થયું કે છોટે સિંહ has not killed Jagmohan's uncle, who is Shivraj Singh. But Jagmohan Singh is having agony over છોટે સિંહ, કારણ કે એને નિર્દોષ છોડી મૂક્યો એટલે જગમોહન સિંહના મનમાં એના માટે દ્વેષ હતો. So whenever they came to meet each other at any public place, એમની વચ્ચે કાયમ નાના ઝઘડા થઈ જ જાય, ઉગ્ર બોલાચાલી થાય, નાની મોટી મારામારી પણ થાય. એક દિવસ એવું થયું, એટલે કે લગભગ 1966 ની આસપાસ એવું થયું કે જગમોહન સિંહ was working in his farm where Chote Singh also was working in his farm as they were having adjacent farms to each other. બંનેના ખેતરો નજીક નજીક હતા. હવે એ વખતે એ બેને સામ સામે જોઈને ફરીથી દર વખતની જેમ ઝઘડો થયો, મારામારી વધી ગઈ. But the village people intervened and dispersed the crowd. એટલે ગામના લોકો જે ત્યાં ખેતરની આસપાસ પોતાના કામ કરતા હશે એ લોકો વચ્ચે પડ્યા અને ઝઘડાને શાંત કરી દીધો. But at that time Jagmohan Singh warned Chote Singh that if now you will come in my way, I will see you. હવે જો તું મને મળ્યો તો હું તને જોઈ લઈશ. What happened in the very next day, when Chote Singh was in his field for some irrigation purpose, એના ખેતરમાં પાણી નાખવા માટે એ પોતાના ખેતરમાં ગયેલ હતો. At that time Jagmohan Singh was also there, and on this day the quarrel started and the Chote Singh was killed by Jagmohan Singh. So the charge were framed under 302 and rest we all know that the capital punishment was implemented to Jagmohan Singh. હવે in this case, for the first time before the Supreme Court of India, the constitutionality of capital punishment was challenged, whereby it was challenged under this golden triangle of our Indian Constitution: right to equality, fundamental freedoms, and right to life. How? and the judges took the view in which way, by following which arguments, relying on which side, Supreme Court narrated the constitutionality, whether of the death penalty, in this way. First, while જગમોહન સિંહનું જ્યારે પણ જજમેન્ટ આપવામાં આવ્યું ત્યારે સુપ્રીમ કોર્ટે એ પ્રશ્નને આ 3 આર્ટિકલના સંદર્ભમાં તપાસ્યો. એમના મત પ્રમાણે આર્ટિકલ 14 કે જે સમાનતાના અધિકારની વાત કરે છે એના સંદર્ભમાં આ જે પનિશમેન્ટ છે, પનિશમેન્ટ વેલિડ છે કે ઇનવેલિડ, બંધારણીય છે કે ગેરબંધારણીય. તો સુપ્રીમ કોર્ટે કીધું કે જ્યારે પણ whenever the capital punishment or any punitive power is used by the judge, જજ દ્વારા જ્યારે પણ શિક્ષા કરવાના અધિકારનો, સત્તાનો ઉપયોગ કરવામાં આવે છે ત્યારે એમના દ્વારા બંને પક્ષને સાંભળવામાં આવેલા હોય છે, પુરાવાઓ ચકાસેલા હોય છે અને ત્યારબાદ એમને શિક્ષા કરવામાં આવે છે. એટલે બંને પક્ષને પેલો ઓડી ઓલ્ટરમ પર્ટેમ વાળો સિદ્ધાંત પ્રાપ્ત કરાવવામાં આવે છે, બંને પક્ષને સાંભળવામાં આવે છે. સો for this particular reason equality before law is followed. સો એક જવાબ મળી ગયો કે આર્ટિકલ 14 નું વાયોલેશન થાય છે કે નહીં. એના સંદર્ભમાં આગળ કીધું કે in other words also, while mitigating all the legal requirements, in each and every case, facts and circumstances are not same. They are different. દરેક કેસના હકીકતો અને સંજોગો અલગ અલગ હોય છે. If they are different, unequals cannot be treated equally. તો જે અસમાન છે એને એક સમાન રીતે ટ્રીટ કરી શકાય નહીં. આથી આર્ટિકલ 14 ની વેલિડિટી જો ચેક કરવામાં આવે તો કેપિટલ પનિશમેન્ટ ઇઝ કોન્સ્ટિટ્યુશનલ.